Hello, everyone. Welcome to the U.S. immigration news. The Trump administration isn't slowing down on its immigration overhaul, and USCIS just dropped a slate of August 2025 changes that could hit you where it matters most: your fees, your forms, even your status. From skyrocketing filing costs to abrupt program terminations, these updates are rolling out fast and furious. If you're in the middle of a visa, green card, or work permit application, you need to know what's coming and how to act before it's too late. In this video, we'll walk through the 10 most urgent USCIS updates taking effect in August 2025, explain what they mean for you right now, and help you map out the steps to stay compliant and keep your case on track. If you are liking this video, please hit the bell button, subscribe, and like it, so that you may get updates straight to your smartphone. Now let's get into the video. Number 1. Green Card Medical Exam Reset Rule. In another little-noticed change, USCIS now mandates that if your I-485 adjustment of status application is ever denied, withdrawn, or remanded, any Form I-693 medical exam you previously submitted, even if still valid, must be redone upon refiling. Previously, a still valid medical exam form could carry over for up to 2 years. Under the new rule, applicants who face an RFE, denial, or issuance of a notice to appear must budget for new medical fees, a fresh exam, and the associated wait time. For applicants already reapplying or those who worry about RFEs, this means extra costs and delays that can push a case further into the future. Number 2, major fee increases and no exception deadlines. On July 22nd, USCIS rolled out dramatic increases in filing fees for almost every benefit request, from work permits and family petitions to adjustment of status and asylum applications. These aren't minor tweaks. Many fees have jumped by 30% to 50%. What's more, beginning August 21st, any application submitted with the old fee will be rejected without review. No courtesy notices, no grace periods, and no exceptions. Imagine preparing your I-485 adjustment packet only to discover that a few dollars shortfall means your entire case is tossed aside. To avoid this, download the updated fee schedule directly from USCIS.gov the day before you file. Cross-check every fee line item and consider overnight or tracked mailing so you have proof of timely payment. Number 3, policy manual revisions and interview waiver end. Finally, USCIS quietly updated its policy manual, removing interview waivers for most routine visa renewals and benefits. What once allowed straightforward renewals, like certain H1B extensions or green card renewals, to proceed without an in-person interview, now typically requires applicant appearance. This policy shift aims to enhance fraud detection, but also means more consular visits, longer wait times at field offices, and added travel costs. Employers and families should budget extra time for appointments and prepare thoroughly for in-person interviews, including updated forms, original documents, and practice answers to common questions. August 2025 marks one of the most consequential months for U.S. immigration policy in recent memory. Between steep fee hikes, form overhauls, status terminations, and elevated scrutiny, a single misstep can mean months, if not years, of delay or the outright loss of status. The good news is that you now know exactly what's coming. By downloading the correct forms, submitting precise fees, monitoring the visa bulletin, compiling social media histories, and seeking legal advice where needed, you can navigate these changes with confidence. Number 4, mandatory use of latest USCIS forms. Effective July 30th, USCIS will accept only the newest editions of core forms, such as I-129 for non-immigrant workers, I-130 for family petitions, and I-485 for adjustment of status. Any outdated form versions will be summarily rejected with no opportunity to cure the deficiency. Even minor layout changes or additional questions can trip up an experienced filer. The best practice now is to download fresh PDFs directly from USCIS.gov on filing day and print only those versions. For large or complex filings, like a blockbuster I-140 immigrant petition, incorporate this step into your final checklist, because an accidental use of yesterday's edition can cost you months of delay. Number 5, immediate end of TPS for Nicaragua and Honduras. As of July 5th, temporary protected status for Nicaraguans and Hondurans has officially terminated. That means individuals who previously counted on TPS to live, work, and remain shielded from deportation now face an urgent cliff. There was no wind-down period. Work authorizations tied to TPS automatically expired, and removal proceedings can now begin without further notice. For those thousands of individuals and their families, the loss of status is nothing short of life upending. If you, or someone you know, relied on TPS, you must explore alternative immigration options immediately, whether it's applying for family-based relief, special immigrant juvenile status, or other humanitarian protections. Time is not on your side. Number 6, employment-based visa retrogression and filing windows. The August 2025 Visa Bulletin brings unwelcome news for many employment-based green card hopefuls, especially nationals of India and China, in the EB2 and EB3 categories. Priority dates have moved backward, a process known as retrogression, effectively closing the door for new filings until the next fiscal year begins. Those who once counted on timely filings to begin adjustment of status now find themselves paused indefinitely. This retrogression reflects unyielding demand coupled with fixed annual per-country caps, and it means thousands of skilled professionals must revamp career and life plans. Keep a close eye on the final action dates chart, as filing under the wrong cutoff can result in wasted fees and delayed adjudication. Number 7, social media disclosure for student and exchange visas. In a move aligned with broader national security concerns, USCIS has added a requirement for all applicants in the F, M, and J visa categories to disclose usernames for every social media platform used in the past 5 years. Beyond mere account names, consular officers may request to see public activity, check connections, and evaluate behavior. Any discrepancies, omissions, or troubling posts could trigger additional scrutiny or even denial of visa issuance or change of status. If you're a student, exchange visitor, or sponsor, start compiling your account list now. Review your public profiles and remove any content that could raise red flags. This process takes time and forethought. Don't wait until your appointment letter arrives. Number 8, Special Immigrant Juvenile Status, SIJS. Protections halted. Perhaps the most surprising shift affects vulnerable youth under Special Immigrant Juvenile Status. USCIS has rescinded deferred action and work authorization for all pending SIJS cases, leaving many young immigrants suddenly without legal status or employment rights. For those who wasted their futures on SIJS relief, often because they have no other pathway and face imminent danger, this abrupt policy change is devastating. Parents, guardians, attorneys, and community advocates must act swiftly to identify alternative forms of relief, whether through asylum, adjustment via family petitions, or U&T visas. Every day counts. Number 9, FY 2026 H1B cap met, H2B extensions, and future proposals. USCIS confirmed that the FY 2026 H1B cap was reached within days of filing opening, as expected. Meanwhile, the Department of Labour has released a small batch of additional H2B visas to address critical seasonal labour shortages in hotels, restaurants, and landscaping. Beyond that, proposals to favour higher-wage H1B applicants remain in legislative limbo. Employers planning for 2026 need to consider alternative visa categories, like O1 for extraordinary ability or adjust recruitment timelines. For seasonal industries, securing H2B slots now is vital, as they're unlikely to reopen once filled. Number 10. Stricter evidence standards for humanitarian and disability waivers. Those seeking naturalization disability waivers, Form N648, face tougher medical evidence requirements, with USCIS officers demanding more detailed reports, standardized testing results, and sometimes second opinions. Similarly, T-visa, U-visa, and VALUA applicants under humanitarian grounds now encounter enhanced anti-fraud reviews, including deeper background checks and mandatory consular or ICE interviews in certain cases. While these aren't immediate denials, they lengthen the timeline for approval and increase the likelihood of requests for evidence or notices of intent to deny. Applicants and attorneys should prepare thorough, well-documented submissions to navigate these higher evidentiary bars. That's all we have for this bulletin. The US Immigration News channel provides all necessary visa information and procedures for your US immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about US visitor visas, such as B1 and B2, work visas such as L1A, L1B and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you haven't already, please subscribe to the US Immigration News channel. Thank you for watching, and we'll see you in the next video.